Okay, we're in. Okay, video stopped.
Okay, so we're the second one.
Did you get that agenda thing that I printed? Did
I
I
did.
get the agenda?
Look at it. Looking at it right here. We're the second,
For the second case to go.
yeah.
I'm gonna close the door for you guys.
So here are the two emails, Rob. When you share screen, you should just go to share. And then whichever you wanted.
That's right.
Sure.
Close that out. So you go to share on the bottom.
Oops, that's not what I meant to open up, sorry. So this
So
is,
just grab it.
so you can just hit share and then screen two.
Good morning.
But they're not, you're not like actually,
Are we? Oh, muted. We're not muted. Good morning.
How you doing today?
We're doing good. We're just working on the screen sharing. Sorry for failing to mute.
That's all right. No, probably I'm early. This is how I do it all the time. I like to be early than late. Hello? Hello? I think it's work.
To be honest with you, because I used to do the border control, do
Yeah.
the resolution.
Yes, yeah.
I was following that format when I
Okay.
came up here, and it's been so long since
see.
You hear me okay?
Yes.
Okay, because I didn't.
Yeah, I can hear you now.
I thought you were reading the preamble and I couldn't hear you. I was getting nervous. Thank you.
Yes.
No, I'm still waiting for Ms. Davis.
Miss Davis is. Hello. Are you there?
Okay, who is this?
David Thompson.
Okay, yeah, we're still waiting for Ms. Davis to give us the go ahead.
Okay, Miss Davis is who?
We're waiting on our side.
We're waiting.
Just hold tight when your docket's called. You'll be able to identify yourself at that point.
Okay, is this the city I'm speaking with?
Yes, this is the Board of Building Appeals.
Okay, question for you. I don't know how this will affect everything. I was gonna when those violations were written out.
So wait till the meeting gets started, and then wait
Okay,
till
no problem.
your hold on. Your docket will get called,
Okay.
and then the chairman will swear you in, and you'll have an opportunity to present testimony. So there's several other cases on the agenda along with you. Okay.
All right. Yeah.
Thank you.
Is this a court hearing we're at?
This is the Board of Building Standards and Appeals.
Oh, okay. I thought it was a hearing.
We're just waiting to get it underway.
Okay, I was just wondering. I didn't know what environment I was even talking with.
Okay.
Hey, Mr. Thompson.
Hey,
Yeah.
how are you?
Okay, yeah, I didn't get an email from you. Can you email it again for me?
Yeah, I'll send over in about. Are you at your office today?
No, I'll be running around today. So I'm supposed to be leaving out of town later on today.
Oh, okay. I'm gonna get it to you. It's just an additional insurance I needed added.
Okay.
We had them like a year or so ago, but I guess I missed them when we hit everything this year.
Uh-huh.
Okay, so I'll give you within the hour.
Call in user 2. You need to mute your mic.
I'll talk to you in a little bit.
Okay.
Out. It's free charge.
Okay. I'm not gonna.
Mr. Chairperson, Mr. Chairman, Mr. Gallagher. We have Mr. Bradley on the phone. He is experiencing some technical difficulties. So he's on the phone here on FaceTime with me, so you can get started with the preamble.
Okay. In compliance with notification requirements of Ohio's open meeting law and section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the city planning department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting has the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the screen. All call-in users can unmute by using *6. All meeting activities being recorded by way of the WebEx platform. These proceedings are also being live streamed by way of YouTube. All requests to speak in a particular matter by way of our website and email have been considered. We have also received emails from those who have provided written comment on a particular matter. Ms. Austin.
Thank you, Mr. Chairman. If we could verify live stream.
We are live streaming.
Thank you, Mr. Chairman. And as we do at the beginning of every hearing since the beginning of the pandemic, the city does object to the use of the chat function based upon the fact that if we were all meeting here in room 514, there would not be side chats. Thank you.
Okay, Ms. Davis, call the roll.
Mr. Maskey,
Here.
Mr. Bradley,
Here. Can you hear me?
yes, we can hear you.
Yes.
All right.
Mr. Dink
Here.
and Mr. Gallagher.
Here.
We have a quorum.
Okay, Board of Building Standards and Appeals is now in session. So we're going to call the first docket, building docket A22-222, 3196 West 44th Street.
Application of, 1 second, please. Application and fees are in order. Notice of violation is no permit, unauthorized illegal use, interior and exterior maintenance, issued on November 30th of 2022. Appeal statement received December 27th of 2022, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton, Law. With the appellant or his or her representative, please state your name for the record.
Joe Mata.
Okay, Mr. Mata, solemnly swear to tell the truth, the whole truth, so help you God.
I didn't hear an answer, Mr. Chairman.
Okay, are you muted, Mr. Mata?
No?
Okay, do you solemnly swear to tell the truth, the whole truth, so help you God?
Yes.
Oh, okay. Okay, proceed. Tell us what your plans are.
Mr. Chairman, preliminarily, there does appear to be a smoke detector issue that is cited, just to bring it to your attention. Thank you.
Okay, thank you.
85% of the, good morning, everybody. Almost 85% of the job is done. And the illegal use was closed by Inspector Derritt because that wasn't true. and I think you have copy of it because I just spoke to her last week. She came. What I need is a little bit more time because of the permit. When I bought the house in 2018, February of 2018, based on a county record, I bought it in June of 2018. All the work been done February of 2018. So I inherited like this. The hot water tank has February 2018. All the PVC has dates, as you know. But she said that was the title company or my job to make sure permits were done by the old owner before I bought the house. Basically, we pull an electric permit. It's on file. And we're in the process, actually, as we speak. I just this morning hang up with my plumber. He's pulling a plumbing permit for as-built, that's the right term, as-built plumbing. Because based on whatever I spoke with her last time she came and she saw everything is done, she need a permit for the baseboard heaters that were existing and for the electric panel that's already existing. And I think there is a permit on file. I have the permit number. Now, all what we're waiting for is one more permit, which is Cleveland Sewer Company is pulling the plumbing permit. So he can come and basically see if anything is wrong and rectify it. Because the hot water tank existing.
Okay. How much more time do you think you need to complete it?
To be honest with you, now was short. Like I've been calling them every day. I can show you proof. We tried to call Miss, I don't know if I'm saying her name right, Finnery, in the permit department. I can pull my phone to see if we can amend one permit, because I was talking to Inspector Derek. She said, see if you can amend one permit to add stuff to it so you can do it. And she said, we have to pull it again. And I think they were backed up because the electrician just texted me this morning. He was trying to get hold of the inspector to come do the inspection and close it because he's done. So, and I have one more situation. I'll be out of town May 29. I'm going out to my brother's wedding. So basically all June, I'm not here.
Okay, but your best guess for completion, considering everything that you've said.
I will say 4 months max. I don't need the whole 4 months.
Okay, all right.
But all what I can tell you, the electric is done. We're waiting on the City of Cleveland inspector to come and see it. And it was done by the certified electrician that pulled the permit. The plumbing, I believe as we speak, he's City Hall pulling a permit because I talked to him in the morning. He was like, I'm parking going up. And beside this, we should be good to go. But the illegal use of dwelling and everything, I think you guys has access to everything. She closed it the day of inspection when Inspector Derek came.
Okay, well, let me go over to Mr. Vanover and see where we go from there.
Thank you.
Well, Mr. Chairman, there is a open violation notice for the exterior maintenance of the rear house, and it appears to be another 3 dwelling unit. The unit closed as well. For the front house that's still open. Those 2 are still open. The illegal use is closed. Mr. Chairman, to the appellate, what permit are you trying to amend?
The electric permit.
Because there's an electrical permit for the baseboard heaters that has been issued.
It is issued, I believe. Yes.
Yeah. What are you trying to amend it to?
She asked for one more stuff, and the electrician know about it. So basically now he's paying for another permit because it's done. So she said, I just want to see a permit on file. So he went downtown and I believe he paid for the permit, and we're just waiting on the electrician, on the electric inspector to come and take a look at it.
So, Mr. Chairman, there's one electrical permit for the baseboard heating. The panel and the rewiring is not permitted. He will need another permit for that. I mean, any electrical work that has been done without a permit needs to be permitted. So that's still in place, and the plumbing permit. So those are not in place. We don't object to more time, but all the work that all the new work has to be permitted, and more importantly, it has to be inspected.
Okay. So if we give the time, then Mr. Amato, you'll be able to take care of this and get it done. If we give you, let's say 120 days to complete this, so that it makes sure all the loose ends are done and taken care of. So that would be September 9th, 2023 to complete all the violations. Motion is in order.
Mr. Chairman?
Yes, hold up.
Mr. Chairman, to the appellate, is this structure empty? Is it vacant currently?
Occupied.
It's occupied? So,
Yeah.
Mr. Chairman, has all the smoke detectors and CO detectors been installed?
Mr. Mata?
Yes.
Okay.
Yes.
Okay. So he's given testimony that they are installed. Are you good there, Mr.
Yeah,
Mata?
then we don't object. I do ask that that Inspector Derrick re-inspect for those issues within the next 2 weeks.
Okay, we can do that. So that it gets re-inspected within 2 weeks by Inspector Derrick. And we'll still go with the September 9th, 120 days, 2023 to complete all the violations. We had, I think Mr. Bradley made a motion.
Yes.
Second by Mr. Maskey.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, you'll be notified within 2 weeks. Thank you. So we go to the next docket.
Sorry, I'm good to go.
You are good to go, yes.
Thank you. Have a good one.
Okay, you too. Okay, we have, gonna ask if we have everybody in place for docket A 423.
I don't see the attorney on yet.
Okay, let's
You
move
do
it.
have me. This is Attorney Rob Friedman on behalf of the building owner. We also have.
Okay,
Morning. We also have Danielle Holyfield, who is the property manager for Shaker Heights Apartments Owner LLC, and she is on as well.
You're ready to go then?
Yes.
Okay. All right, so we'll call the docket A 423 12701 Shaker Boulevard.
application and fees are in order. Notice of violation is interior and exterior maintenance. Issued December 8th of 2022. Appeal received January 4th of 2023, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing. I'm gonna ask you to mute your, thank you. Patricia Ashton, Law. We also have tenants inside to give testimony. I'm gonna ask them to state their first and last name. You start, you sir?
Ronald James. Jackie Hicks. Regina Burton. Jay Westbrook.
So you want them to raise their hand so you can swear them in, Mr. Chairman?
Yes, we have the attorneys on also. So whoever is going to be given testimony, I need to solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Mr. Chairman, preliminarily, as we usually do, through Mr. Vanover, upon conclusion of the evidence testimony, presented today, the city is gonna ask that you uphold the notice as properly issued, deny further time, and remand to building and housing. Thank you.
Okay. So we'll get started. Who is going to be speaking first on this property?
I'd be happy to start.
Okay.
Mr. Gallagher, my name is Rob Friedman. I'm the attorney for the appellant.
Okay.
As recently as 30 minutes ago, I've spoken to Inspector Karen Harris of the city of Cleveland. Her position with respect to these violations is, I think, substantially different than what you may hear from the tenants and what you may hear from the Department of Law. She has been effusive in her praise of the way that Ms. Holyfield has handled this situation. These violations were notified on December 8th in the middle of cold winter season. And while certainly many of these violations are interior, there are also some that are in exterior violations that are dependent upon weather and the cooperation of contractors and their ability to perform in winter weather. During the period of time that the violation notices were pending, my client also, like many property owners in the city of Cleveland, on Christmas, December 24th, suffered catastrophic losses as a result of a temperature change that was more than 40 degrees, causing their 100-year-old boiler system to have a catastrophic failure. So the focus on these code violations was necessarily brought to the health and safety issues that this building was confronted with. We worked with the city to complete and repair those conditions.
Mr. Chairman, is the council for giving testimony today?
Is who?
I would also, is the council appears to be giving testimony as to factual matters before this board. I would also state that the city objects to council, based upon ethical obligations, not contacting the city's inspector without notice to the city's attorney. There's ethical obligations regarding that. He most certainly could have subpoenaed her to be present. Mr. Vanover, as the designated person for the building department before this board, presents the city's position. It is not the law department's position. It is the building department's position. But if council is going to give testimony, I would state we have an issue with him being attorney advocate giving testimony. He says he has the property manager present. He most certainly can present testimony through the appropriate means.
I intend to do that. If I can
Okay.
complete my preliminary statement. I'd
Okay.
like to-
I wanted it clear, that's what that was, sir. You seem to be giving testimony and although the board can hear hearsay, you're talking about what the city's witness, if I may, you're talking about what the city's witness inspector would have said to this board had she been present, which she is not. Thank you.
I've not tried to testify on behalf of the inspector. I've rather tried to make a preliminary statement. And with the permission of the board, I'll continue to do that. I can report on behalf of my client that all of the violations on this list, notwithstanding the conditions that they were confronted with on Christmas and on an ongoing basis, have been completed with the exception of 3 items that Ms. Harris has indicated remain outstanding. Those items, one of which is related to the sanding and repainting of a wall that was cited for having peeling paint. That is violation number 38 in unit 516. Whereas Ms. Harris has indicated that, and I can pull that up on my screen share.
No, we do not allow, you were instructed when you got your notice of hearing, anything that you wanted to submit for the board to review had to be submitted by last Friday.
Unfortunately, the inspection didn't take place until yesterday. So for that reason, that document was not available to me. Otherwise, it's certainly would have been submitted. But the fact of the matter is that I have received information from Ms. Harris that all but 3 of the violations on the 45 violation list have been completed. 2 of those are in progress presently. The only violation that remains outstanding is related to a window replacement. The window is in the possession of my client and cannot be installed unless and until some tuck pointing work is completed around that unit because of a motor vehicle collision with the building. Once the tuck pointing, which is weather related, can be completed, I'd be pleased to report back to the city that all 45 violations that were cited on December 8th will be in completion and compliance with the city. But in fairness, under the circumstances that they were confronted with as a result of the storm on the 24th of December, and as a result of the weather-related condition associated with this window replacement, I would ask that the city provide an additional 60 days within which to finalize these remaining violations.
Okay, so you do not object to any of the violations that were cited. Is that correct?
Don't object to the violations themselves. I would state that the amount of time given under the circumstances was inappropriate. I would further note for the board that we have complied with everything on the list that can be complied with short of weather-related issues.
Okay, how much time do you think you need?
Because of the window and the tuck pointing and the availability of contractors on that specific violation, I'm seeking 60 days, Mr. Gallagher. With respect to the other violations, I'm requesting 30 days to have them completed and re-inspected. I understand that Ms. Harris is no longer in her position, so it would require the assignment of a new inspector to finalize these. So for that purpose, for that reason, I think 30 days would be appropriate.
Mr. Chairman, preliminarily, if, since the council, is still giving testimony, but if we could ask that the, whatever information he has indicated through his testimony to this board to be forwarded to the city, Mr. Vanover and myself, which would be appropriate. If he has information that he's obtained, the city is entitled to receive it. Again, objecting to his, in a pending matter, reaching out to the city's personnel when the city's personnel are represented in this. It may be an administrative matter, but it is still a pending matter. Thank you.
Okay, so the request is that you give the information that you were, I think, going to show anyways, to the city, to the building department.
I'd be happy to do that.
Okay, very good.
The email from the city department was received today at 9:04 a.m. and that's the reason why it was not submitted.
Okay, Mr. Vanover.
Mr. Chairman, so that was a lot. There's several notices of violation on this property that have been issued over the past, beginning in August of last year, are the most recent ones. So I don't know which specific violation, again, is under appeal here. But I will argue that although there was a weather change, the expectation of a commercial property owner in the city is that they maintain their property to a condition prior to the city needing to come out, inspect, and cite it. So the fact that the work has been completed, allegedly, and I would need to look through the inspection records because I don't have that document. There's an expectation that it should have been completed before the city needed to cite for it. That's the responsibility of a commercial property owner. I will also note that there are multiple complaints from multiple persons on this property. As early as last Wednesday, we received a complaint for collapsing walls due to water from the radiator upstairs. So I would ask that you remand it back to the Department of Building and Housing for monitoring Ms. Harris will remain, whether she's in her position or not, she will remain on this case until it's completed. So, we would ask that I don't believe that it's necessary, to grant more time for work that should have been completed in the first place.
Okay, so there are some, there are residents to this, or there's some people that I think that have shown up in the office that may want to speak on this issue. So I would like to go ahead and give them an opportunity. Ms. Davis?
Okay. When giving your testimony, again, could you please state your first and last name and which unit that you live in? Okay? You want to go first, sir?
Excuse me, Ms. Davis, this property has 3 different buildings, so I think it might be valuable if the people who are testifying indicate what their full address is, because there are other buildings that have separate and distinct code violations. They're not the subject of this matter. Thank you.
Thank you.
My name is Ronald James. I'm in 12701 Shaker Boulevard, apartment 406. As I was going to get my car in the basement of our apartment building, there was flooding in the basement because water was coming in from the opening in the basement. There's a door you go into the garage. Next to it, there's an opening that's about maybe 5 or 6 feet above the ground, but there's enough room for a maintenance man to go in and repair the steam pipes and the water pipes. And water was coming out of there, and it was flooding the basement. You know, this had happened a couple of weeks ago, but when it rained, but it hasn't rained in the last couple of weeks, and everybody's concerned about why is there water coming out of this opening into the garage. Number one, go back to the heating. We did not have heat all from January of 2022 until the weather turned warm in 2022. So the fact that the boiler went out in December is not something that should be a surprise to them. They told us that they had fixed this. You know, they haven't had any contractors to come out to do the work. All they have is they hire people off the street to do the work. These people don't have any name tags. They don't have any uniforms. The residents don't know who they are. We don't know if they're licensed, bonded, or anything. And there are a bunch of liens against this building from contractors that haven't been paid.
Objection.
So I don't understand why they're talking about contractors coming in if no contractors will come because they don't pay them. They're behind on their water. They're behind on their heat.
Hold on one second. He has an objection that the board has a right to. Mr. Chairman, in response, this board regularly hears hearsay matters, the rules of evidence and the rules of procedure, as you know, because this is a statutory, special statutory proceeding. This board has the right to hear and frequently does hear hearsay. In fact, did hear so from counsel himself this morning. So in the scope of both rules of evidence and clear in Rule 1, they are advisory to this board. We would ask that you allow to hear from the people who are living in this condition. And in this, he clearly stated he lives at this property. So he has a right to be heard by this board. Thank you.
Your Honor, my objection doesn't relate to any rules of that the council had cited. My objection relates to the relevance of whether or not my client has a lien on their property. Anyone who has a mortgage has a lien on their property. Cities and taxing authorities can put liens on property. That should not be have any bearing on whether or not the violations that are cited in the December 8th notice of violation have been completed or are worthy of an extension.
And the city and this, Mr. Vanover, if I could just reply. And Mr. Chairman, as stated previously, it is clearly relevant. He lives there. He is stating his opinion, and this board has the right to hear that, and he has the right to be heard on that. Thank you.
Right, and we're gonna let everyone that has something to say, and if you want to take notes on that, Mr. Freeland, and then respond afterwards, that's fine. You can do so, and if we know that there is no contractor liens on the building, fine, you can state that. So we're gonna go ahead and proceed to hear this testimony.
Mr. Chairman, if I may, to Ms. Davis, if you can identify specifically the notice of violation that is the subject of this appeal, the violation number.
To Mr. Chairman, to Tom Vanover, the violation number before us today is V as in Victor, 220-31987.
Thank you. Mr. Chairman, before we continue and with the rest of the testimony from the residents, I will argue that there are multiple notices of violation that remain open on this property. And by multiple, I can count them, but there is active 2, 4, 5, 8, 9, 10. More than 10 notices of violation on, if not this property, within this complex from different units, including an elevator violation. The appellant through counsel has already stated that the work is not complete. And it's almost complete or nearly complete, and that may be the case for this specific notice of violation. But there are multiple other notices of violation that are not under appeal, and the records do not indicate they are complete. So I would restate that at this point, I would ask again that you deny any more time, remand it back to the Department of Building and Housing, so that any extension of time on this notice of violation is irrelevant, because there's so many others as well, and they're not complete.
Okay, so because we have before us with this docket, 8423, and to what it involves, and what you're stating, I think, Mr. Vanover, is that there are other things that are at issue. And although the 45 that I think that the attorney's talking about have been, or he believes that they've been taken care of already, and that the only thing remaining is that window that has to be done in the tuck pointing. That's his statement. So if there's other ones that we don't have in front of us, and even those that are speaking on it, I think we should keep it to this particular what we're looking at here right now. Now, you may be issuing, I guess, and you can correct me, Tom, you're going to be issuing more violations on other parts of this. Is that correct?
No, Mr. Chairman, that is not the expectation.
Okay.
Our expectation would be to continue through our enforcement of the 8 others that are still open.
Okay.
Mr.
Okay.
Chairman, Mr. Chairman,
Yes.
On this violation notice, do you want me to read into the record the unit numbers that has been notated on the violation notice? Or do you want to continue to hear testimony from the tenants that are currently here as well?
Well, if it's on that notice and you know that it is, then yes, we can just continue and hear it. Okay. If it's, well, it would have to be on that notice, because that's all that the city has put forth. So, so I think we're good to go to just continue to hear them.
Okay. Were you done, Mr. James?
I just wanted to say that the reason I brought up about the contractors was the fact that no contractor will come there because they have these liens on the building because the contractors haven't been paid. And we have not seen any contractors at this building. The only people that have done the work have been people that they've hired off the street. We don't know their qualifications. We don't know who has, if they're a competent architect or engineer, has overseeing their work to see if it's done correctly.
Oh.
And the passenger elevator's been down almost 3 months.
And Mr. Chairman, in fairness, there's a pending matter not for this board that's on appeal, in fairness to the appellant.
Okay.
It looks like, the attorney has his hand up, Mr. Chairman.
Okay, go ahead, Mr. Freeman.
Yes, I just wanted to reiterate what Mr. Gallagher said, which is I don't think it's appropriate to go outside the scope of the violations that are the subject of this appeal. We may or may not appeal other pending violations, and the testimony of the tenants would not be relevant unless it relates specifically to one of the violations that are on this case. To bring in external issues by the city is really, in my view, to perpetuate a narrative that this company is terrible. And because of all of these violations, many of which they had inherited, having only been the owner of the building for about a year,
And I'm going to again
are
object to giving
are somehow their fault. And I agree with Mr. Gallagher that the violations that are the subject of this appeal should be what's considered by the board and nothing else.
And Your Honor, Mr. Chairman, if I may, because appellant's attorney seems to continue to give testimony, although he identified a Ms. Daniel Holofield, he didn't bother to put her on. And I would state that it is relevant to the conditions and the general common areas that a resident is dealing with and as cited. But if he'd like to continue to object instead of hearing from the parties, which this board has a right to hear from, because it is clearly relevant as they are living in this property. Thank you, Mr. Chairman.
Okay. Well, Ms. Davis can look at where the violations are as they're going to give the testimony, and so we'll use her as the filter for that for the rest of the testimony. So you can go ahead and proceed.
Okay.
Jackie Hicks, 12701 Shaker Boulevard, apartment 317, Cleveland, Ohio, 44120.
I'll ask you to speak up a little louder so they can hear you and pick up on you.
Okay, my name is Jackie Hicks. I'm at 12701 Shaker Boulevard, apartment 317, and that's Cleveland, Ohio, 44120. I'm here to speak about some of the conditions, and I'm going to have to move, and I feel like they should be responsible for the moving expenses and things. It's leaking down my walls in my cabinets. They haven't did anything. I've called and called and called. I'm being told by Section 8 I have to move because the place then went in abatement. Basically, I've dealt with going back and forth about repairs, and I've even spoken with the owners. I have a lung disease. When the water and lights and stuff like that are out, I can't use my breathing machine. I have several notices here. Several. They've been given plenty of time to do the repairs. I've had several notices that they going to shut off the water. They're going to shut off the heat. They're going to do this. They're going to do that. And we haven't had any repairs. It's a mice problem in the unit. I have a letter for Danielle Holyfield stating that they don't have contractors and they're going to do what they can with the repairs. And now I'm stuck between a rock and a hard place of having to move because my repairs haven't been done. And I feel that's unfair to me and the other tenants in the unit. Here's the failed thing where it went into abatement.
Failed by CMHA.
By CMHA. So this is the inspectors here are just not the only entity.
Copies for our records.
Are not the only entity. When the elevators and stuff are down, I have to come down 32 steps with lung disease to get back and forth to my apartment. It is ridiculous. I've spoken to the owner several times. Several times, nothing has been done about it. I received a refrigerator and stove. I had to clean the stove and the refrigerator was full of blood. I got pictures of that. when it comes to doing repairs, this is ridiculous of how I've lived, no heat. And my case has been in court since October of 2022. This is really ridiculous. And I've suffered health conditions and everything.
Go ahead.
This is,
Chairman, the tenant has a bunch of papers for the board regarding her testimony. If the board could send them to both council and I. You're going to be keeping it for the record, I presume, but it can be scanned in, even if it's after this hearing, so that it can be sent to both council and myself. Thank you.
Yes.
So we want to get this as,
Wait.
there's one more.
Okay.
It's the road and abatement program
Okay.
by CAT.
Thank you. Is there anything else?
that's it. I'm gonna have to move. I have 2 or 3 cases with them. I've tried to deal with them. The repairs are not being done like they're supposed to. I'm being given excuses. The water, the lights, and all that is constantly off, and I'm on a breathing machine. And something has to be done immediately. I'm gonna have to move. Then they have the nerve to ask me for a rent raise. They want to raise the rent. Okay, so that's it. I can prove everything I say though.
Thank you.
You're welcome.
Ma'am, did you still want to give testimony?
Hi, yes, my name is Regina Burton, and I live at 12500 Shaker Boulevard, Cleveland, Ohio, 44120. I submitted my 30 days, now going into 3 years. And in that time, not one of the violations have been done. I had my court date on the 9th that just passed. And again, there's no movement, nothing. So the magistrate asked me, do I want to go to court? And the attorney for this company, said that he wants to settle. Now, my thing is this. Several people in my building that their lease was due, they would threaten them with raising the rent to $1,000. Most of them are in the same shape that Davis is today. I just don't understand how we can be forced to live in filth. And tremendous mold. The mold is getting so bad where the parking area is almost on the full length of outside. The mold is just growing. The mold in the main, parking space, they're painting over. They're not, actually fixing. Okay. I just want, somebody to be held responsible.
Thank you. Mr. Westbrook, did you want to?
Thank you, Ms. Davis, and to the chair, the members of the Board of Zoning, Board of Building Standards and Appeals. I am not a tenant of any one of the 3 buildings owned by this ownership group. However, I'm active with a civic organization that it is vitally concerned about the maintenance and upkeep of the historic buildings in the immediate vicinity of Shaker Square. I came to know the tenants of 12500, 12600, and 12701 in January of 2022, when the current ownership group, led by a real estate family in Manhattan, New York, the Chetrit, Chetrit family, purchased the property. In January of 2022, there was no heat in the building of 12701. And as Mr. James testified earlier, tenants lived without heat up until the warming period of spring of 2022. The months of warmer months of spring, summer, and fall of 2022, there was little or no work done on the boiler system. There were no licensed contractors on the scene at all. And so as soon as the winter conditions of late 2022 hit, and the attorney for the appellant testified on Christmas Eve, the catastrophic conditions, the catastrophic conditions hit a non-functioning unit. The heating system was not functioning anyway. So this issue about kind of being knocked off their standing really is, I think, not accurate. I've been involved directly with tenants. I've experienced many of the conditions. I've seen the walls covered with mold. As recently as this morning, I was stuck on the one and only operating elevator. There's a classic problem with the door not opening on the fourth floor. And without thinking, I took the elevator to the fourth floor and I could not get off the elevator. I had to take it to another floor. That's the one and only elevator that works in the building. So I know firsthand many of the conditions. I'd like to almost bring this right to 601 Lakeside. I learned to my surprise and pleasure that a retired city employee lived in 12701. And I'll say his name because he was active with the tenant group, Mr. Tony Dial. He was ordered by his personal physician to move because of a pre-existing heart condition that was not safe for him to continue to live in the unheated building. And since then, Mr. Dial has unfortunately had to move. I have seen, as a former councilman, I've seen cases come before the Board of Building Standards and Appeals. I have great respect for the judgment of the professionals that are on the board. In hearing Chief Building Officer Vanover's testimony, I, as a supporter of the tenants and a supporter of good, safe, quality living in the Shaker Square area, I support Chief Vanover's position that the case be remanded to Building and Housing. Building and Housing has extended a great deal of time, effort, flexibility to a company that has not shown the right kind of respect or the right kind of response. We don't even know at this moment who any contractors are that are working on these deeply impactful systemic problems in not only 12701, but the other two buildings as well. Thank you.
Thank you. I think that was the last one that was there, Ms. Davis.
That is correct.
Okay, I'm gonna let Mr. Freeman a chance to go ahead and respond to what any of the comments are, hopefully briefly. But
I'll be very brief, and just to remind the board that each appeal should be considered on its own merits. I'm not prone to hyperbole about how terrible and horrible things may be without evidence in support of that. I guess what I would remind this board is that it is easy for a party to perpetuate a particular narrative based upon what's important to them. The city of Cleveland, Ms. Hicks, and Mr. James all have pending civil litigation with my client. It is inaccurate to say that the Chatreat family purchased this property. This property is owned by Shaker Heights Apartments owner LLC and no other party. If you were to speak to the relevant people in this matter, which are Ms. Harris, the actual building inspector, and Mr. Sugar, her supervisor, who received her most recent report, they would tell the story. And the story is that between December 8th and the present, there has been substantial compliance. If not, but for one weather-related issue, there would be complete compliance at this point. My understanding of the city's codes is that they exist to perpetuate code compliance, not to be punitive toward real estate investors and other people who are investing in our community. I'm aware that Mr. Westbrook, who is not a resident nor a member of the city, has stated publicly that all of this money that is being generated through tenant rent payments is being rushed back to New York and other places and not being reinvested in the building. That statement that he has made publicly and the statements that he continues to make are demonstrably false. I can, with evidence, prove those to be false. The narrative that is being perpetuated is to try to get this board to generate another criminal case against my client. That is my personal belief. And I don't believe the board should be utilized for that purpose. There are a lot of narratives being perpetuated about this client. At the end of the day, the question is whether or not it is appropriate to prosecute this client for the conditions that are the subject of this appeal. And I believe the answer to that is squarely that it is not. And I would ask for a small amount of additional time to achieve the compliance with this one and continue to do the work to bring this property that is more than 100 years old into current state of functioning.
Mr. Chairman, if I may very briefly, on behalf of the city, before Mr. Vanover again, I believe is going to ask that you uphold, deny, remand building and housing for further proceedings, and whatever those proceedings are is not under this board's purview. For someone who, I won't go there. I was going to say, I will stay nice, because it doesn't get us anywhere. So let me retract my previous thought. Mr. Chairman, yes, council and I absolutely agree on something. So we're gonna send up fireworks. The intent is code compliance. Absolutely, as that is what this board hears us say regularly for every appeal and for every matter before this board. In the 17 years I've been here, that's always what we've demanded. And instead of presenting the witness that council said he had, he presented his own arguments and opinion to this board. So this board has heard from the residents, this board has seen the evidence presented by the building department and arguments presented before it. So we believe that we have met our burden, that the matter, well, if this violation notice is in substantial compliance, the city applauds that because that is what we want. So that would be determined outside of this board's purview. Based upon all the evidence testimony presented here today, Mr. Chairman, there is no need then for additional time. So we would ask, under council's own arguments, he's got substantial compliance, we would ask that you uphold, deny, and remand based upon that alone, let alone the fact that these residents should have their voices heard. We thank them for being here, and we are glad if that is true. I'm not the inspector, but I'm glad if that is true, that there is substantial compliance, and we would move forward. Thank you, sir.
Mr. Vanover.
Mr. Chairman, thank you. I will restate, for the record, The indication that this property has only been in this ownership, and it is a corporate ownership. It's not owned by people. It's owned by corporation, a corporation, and that the fact that it's only been owned for a year and that they're not responsible for these conditions. I will state that as I have many times in many cases, the condition of this property informed its purchase price. It was not a secret, the condition of this property when it was purchased, and therefore the purchasers and the owners are responsible for that. I will also remind that as Ms. Aston said, that this board is not being used for any purpose other than to gain more time by the appellate. The board doesn't have prosecutorial power, and it cannot be used for the purpose of bringing a criminal case against anybody. So I object to that statement. And that, but what has happened is that this appellate has come before this board requesting a variance based on information that they have provided because they've admitted that the work is not complete. And they're requesting that variance based on the board's ability to believe that they are going to do the right thing and do what is required. I bring to the board the fact that there are multiple violations throughout the complex that this owner owns, throughout this property, and the best indication of future behavior is past behavior. And I pose to the board that mitigating factor is not believable because there is no viable reason to believe that they're going to do what they're posing they're going to do, because there's still multiple violations out there and that are still valid that are not before this board. And so that is where the other violations and the other documents, the other citations from the city become valid in this matter, because they don't support what the board is being told here, that they're going to finish up and wrap this up, because there's multiple problems in multiple places. So that being said, I believe that the city has shown that the violations do exist. The appellate has agreed to that. I also believe that the city has shown that there's no need for additional time. We ask that you deny additional time, remand it back to the Department of Building and Housing. None of that keeps the owner from doing what they are required to do for their asset and for their property. Thank you.
Yeah, just one little clarification in there, because I did not hear the word variance earlier on. I know they're asking for more time. Was there an ask for a variance, Mr. Vanderwerf?
Mr. Chairman, as structured, that the appellate has a right to do two things before this board. They have the right to contest the decision of the Department of Building and Housing, which they have not done, or they have the ability to ask for a variance. In this case, they're asking for a variance from the order that this work be complied with in 30 days. So the request for more time structurally is a variance request. And we ask that you don't grant that variance, that you hold them to the original time period provided. Of course, the automatic stay for these proceedings will then be added to that. But we ask that you deny any more time and remand it back to the department.
Okay, I'm going to form the motion, and then if the board members want to either object or not agree to it, they can vote against it. But a motion is in order to deny more time and remand the property to the Division of Building and Housing for any further action. Motion?
So moved.
Okay, motion by Mr. Maschke.
Second.
Okay, second by Mr. Dink.
Mr. Maschke,
Yes.
Mr. Bradley, you're muted.
Yes.
Okay,
Mr. Dink,
Yes.
Mr. Gallagher.
yes. Okay, so you'll be getting a notice within 2 weeks of that decision. And I think as you heard Mr. Vanover say, this does not stop you from moving on and completing everything as you had intended to do. Thank you.
Thank you, Mr. Chairman. Thank you for showing up and appearing. We're going to move on to the next one.
Thank you,
Thank
Mr.
you for
Chairman,
listening.
and members of the
Thank you.
board. And thank you, Ms. Davis.
Thank you.
Have a great day.
We will now.
Is it possible to get the notice?
They're gonna move on. You'll have to contact her.
Okay.
They have other.
I understand.
Okay, we're gonna call the next docket, A723 7812 Euclid Avenue. At the same time, we're gonna be calling docket A186-23 because I guess it's relevant that they both be, or is it A22?
It's 22.
It's 22. Okay, excuse me. A186-22 7812 Euclid Avenue, that they're going to be brought up together.
Application and fees are in order for docket A723. The notice is failure to register, issued on November 10th of 2022. Appeal was received December 13th of 2022, requesting for time for docket 186-23. This is a time extension from the original docket heard on September 28th of 2022. It was at that time the board granted them to November 12th of 2022 to abate the hazardous conditions that was issued on May 19th of 2022. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston, Law. With the appellate or his or her attorney or representative, please state your name for the record. Pastor Kelly, are you with us today? I don't see her, Mr. Chairman.
Okay.
If you swear in Mr. Vanover, I will do my service inquiry, Mr. Chairman.
Okay, Mr. Vanover, solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Thank you, Mr. Chairman. To Ms. Davis, did the notice of today's public hearing regarding these two dockets, A7-23 and A86-22, as it relates to 7812 Euclid, get returned to this board's file for any reason?
Mr. Chairman, to Ms. Aston, no.
And Mr. Chairman, to Ms. Davis, have you had any communications with the appellant regarding these two dockets?
Mr. Chairman, to Ms. Aston, no.
Mr. Chairman, notice having been properly given and not being returned to this board, absent them coming in the next 2 weeks or being returned, this board has the right to proceed. I anticipate that Mr. Vanover is going to ask that you uphold deny remand. Thank you.
Okay, Mr. Vanover.
Mr. Chairman, thank you. So this, excuse me, the violation before us is failure to register the facade of this building under our facade ordinance and pertinent structure ordinance. It basically just requires that it to be inspected and to be, the condition reported to the Department of Building and Housing. So we would ask that it's required of every significant structure that is 5 stories tall or 75 feet tall. This building falls into that category, so we would ask that you deny more time and remand it back to the Department of Building and Housing.
Okay, motion is in order to deny more time, remand the property to the Division of Building and Housing for any further action.
So moved.
Okay. All right, moved by Mr. Dank, second by Mr. Bradley.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, the notice will be sent out within 2 weeks. Okay, we have, next docket is,
Mr. Chairman,
yes,
was that also the same ruling for docket 18622?
I'm guessing yes, but I'll ask Mr. Vanover.
Well, that has a hazardous condition and a failure to register, Mr. Chairman, so we believe it is appropriate. I just want to say that before Tom states anything. Thank you.
What is that the 2020 East 79th Street address?
Let's see, that's still
7812
7812.
Euclid.
It's the same address, right? Yeah, same address. It just, one was time extension and the other one was carried the rest of it that they're not, they didn't,
Mr. Chairman, the hazardous condition is violation V 220-12984 regarding Northwest Valley beam, a structural member of the roof deteriorated, susceptible to failure, in addition to the facade. The same facade violation notice is in docket A-723, but
so are you saying we're covered on both of them with the last motion, or we need?
I would argue yes, because you opened them together and rolled together. Thank
Okay,
you.
all right, we're good to go. Thank you.
Okay.
Thank you.
Okay, housing docket A 21722-11410 Superior Avenue.
Application and fees are in order. Notice of violation is exterior maintenance, issued December 2nd of 2022. Appeal received December 20th of 2022, requesting for time. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston Law. Would the appellate or his or her attorney or representative please state your name for the record?
You see Teresa Thompson?
Is Teresa or David Thompson present?
Yes. Yes. Can you hear me?
Yes.
Oh, okay. Yeah, 90, if I could get an extension, everything will be completed. There are two windows.
Sir,
Hold on.
You gotta swear.
1 second, Mr. Thompson.
Okay.
Okay, solemnly swear to tell the truth, the whole truth, so help you God?
Yes.
Okay, you can go ahead and proceed.
I just need an extension. The violations entitled the grass being cut, and it's been cut. They had added on a soffit that had come out while I was doing a repair on the roof. It's been replaced. There are two windows in the front where I had a break-in and the furnace was stolen. I boarded it up and put a bar on it. Both those windows are in the shop and will be installed within 2 weeks, if not sooner.
Mr. Chairman, to the appellant, sir, did you transfer this property?
I believe it was transferred over to my LLC, DL Thompson LLC. That would be me, one and the same.
Okay, so he's the same. So, Mr. Chairman, although he's transferred it, he's accepting responsibility as basically running his LLC. Thank you.
So he's allowed to speak on it, plain and simple, right?
I'm not going to object to that, correct?
Okay. All right, Mr. Vanover.
So, Mr. Chairman, it does appear that we don't object to more time. However, permits will be required for the window replacement. Those permits must be taken out by a contractor.
Sir, those are not window replacements. They're simply window repairs. They broke out the window pane.
Mr. Chairman, the notice of violation says obtain building permit for all boarded windows. Is your argument that if you expect to argue that case, you need to argue it for the board?
And
So-
Mr. Chairman, 310309 specifically, there are provisions in the code requiring permits for boarding. Thank you.
So, Mr. Chairman, the appellate, what is actually being done to the windows?
The window pane is being installed. It's actually at the shop now. They're basically putting in with the newer windows, it's double pane, something that I couldn't do myself. So the hardware is replacing the two pane, repairing. The frame is staying the same. They're installing two pieces of glass on both sides. That's a repair.
Mr. Chairman, are these wood windows or vinyl windows?
They're vinyl. It's a new house. It's a newer house.
Okay, so Mr. Chairman, based on that testimony, it does constitute a repair.
Okay. All right, so he's saying 2 weeks to be able to complete that.
You don't object to
Yes.
that, Mr. Chairman?
Is that correct, Mr. Thompson?
Yes, in 2 weeks I should have that in.
Okay. All right, so
I can call the inspector out to inspect it. Will it be a need to come back to that case with you guys or not, once he okays it?
No,
Okay.
Mr. Chairman, we
Yeah.
ask that you grant more time. The appellate will not need to come back to the board, only to satisfy the requirements within that time.
Oh, I'm sorry, I misunderstood him. I thought he meant should the inspector come out and inspect the work.
Yeah. Yeah,
I
they
think
should.
that's-
Yes, the inspector should, but Mr. Chairman, I believe he's asking if he needs to come back to this board.
No, you're done with that. But you do need to get the inspector out. So we'll give it to June 9, 30 days to make all that happen, 2023.
I appreciate it. Thank you.
Okay, you get notice within 2 weeks. Thank you.
Mhm.
Okay, next docket is.
Mr. Chairman,
Yes,
you didn't do a motion, did you? I didn't call the roll.
no, we did not. We'll have to do a motion. Go ahead. 30 days, Mr. Dank.
So moved.
Second, Mr. Bradley. Okay.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay. Notice will be sent within 2 weeks.
Thank you.
Housing docket A 21822, 2236 East 97th Street.
Application and fees are in order. Notice of violation is exterior maintenance. Issued December 2nd of 2022. Appeal received December 20th of 2022, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston Law. With the appellant or his or her attorney or representative, please state your name for the record.
You speaking with me, Thompson?
Okay, sounds good.
Yes.
Solemnly swear to tell the truth, the whole truth, so help you God.
Yes.
Okay, go ahead. Let us know what you're gonna do here.
Okay, and the same difference here, it's a property that I'm doing some work on. I did let it get out of hand, the front lawn. I've been working, having work, landscaper guy working on the front for the last week. The front is basically done. They're going to be trimming it. Everything's cut. There's a couple pieces of wood that needs painting because of weathering, and there are 3 vehicles in the driveway that's unplated that'll be towed out again this latter part of this week or first of next week. So I've got Truly Blessed Towing coming out to tow all the vehicles out, and the exterior will be complete.
How much time?
Again, 30 days.
Okay. Mr. Vanover.
No objection, Mr. Chairman.
Okay, so let's see. We're looking at June 9th, 30 days, 2023. Motion is in order.
Move.
Okay, Mr. Bradley.
Second.
Second, Mr. Maskey.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes, notice will be sent within 2 weeks. Thank you.
In the same case, I'll have the inspector come out and inspect. If it's no problem, I guess I wouldn't have to come back to you guys at the second hearing.
Just so Mr. Thompson is aware, the city will object if he comes back and asks for additional time, Mr. Chairman.
Yes.
Yeah, no problem. I think you just,
Okay.
yeah,
I'll take care of it now.
okay. Okay, housing docket A 21922, 2233 East 87th Street.
Application and fees are in order. Notice of violation is exterior maintenance. Issued December 2nd of 2022. Appeal was received on December 20th of 2022, requesting for time. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston Law. With the appellant or his or her representative or attorney, please state your name for the record.
David Thompson.
Okay, Mr. Thompson, once again, solemnly swear to tell the truth, the whole truth, so help you God.
Yes, I do. Same case scenario here. Grass needed cutting. It's been cut down to below what it needs to be and trimmed. There is some exterior work to be done along the trimming on the front porch, and a couple places there's exposed wood from peeling paint that's being taken care of. I'm in the same timetable with that.
Okay, 30 days is what you're saying?
That's all. That's all I need.
Okay, Mr. Vanover.
Mr. Chairman.
Everything's minor.
Okay.
So at this point, I've got to ask the question. These are investment properties, all in the same general area, all of which required some it required intervention by the city inspector. And I'm going to ask, Mr. Chairman, to the appellant, why there seems to be a problem maintaining the rental properties owned by this LLC.
Well, again, we got the notice regarding the grass. I don't know, in December. Again, it was, I guess, late fall. It wasn't cut, and so it was cut since then. I don't know how, where they thought the peeling paint, but the peeling paint was done. Obviously, it wasn't done during the winter, but otherwise, the place is in pristine condition rather than that exterior left the place, and that's being taken care of. I've got a landscaper, as I mentioned, currently working on East 97th, and he's hitting, actually, there's one other property that's the same difference. He's going to be cutting the grass. That was the violation, and a fence with one post that was leaning that they wanted straightened. So everything that there is being indicated is, in my opinion, maybe, and I know the others might be a big, it was nothing that was severe. Again, it was grass cut. All the grass has been cut, landscaping taken care of, and it's basically touching up. It's vinyl siding on all the houses, so there's no maintenance work to be done. Windows broken out, again, by first property was by theft. The second was by vandals that threw a rock in. So it's all minor.
Mr. Chairman, the city would take umbrage with that description. It is not minor. It is not just grass. If you look at each individual violation notice, sir. So it is incumbent upon property owners to maintain their property and not have to be notified by the city to maintain that. It is Mr. Thompson and Ms. Thompson's decision to own multiple properties and rental, then with that benefit comes the burden, as we've often said to this board. So we would ask the board to take note that it is not just grass cutting or these are tenants that deserve to live in properties maintained. Thank you, sir.
Yeah, even if it was just grass cutting, yeah, I mean, it's something that you should be doing anyway. So, okay.
I wasn't belittling anything being minor. Like I said, what I might see as minor is major to someone else. Again, it was December that we were cited, early spring. I do all my spring cleaning on the outside. I even plant flowers in the yards, even though they may not be of need, and mulch, et cetera, installed. And so I'm not belittling it, calling it minor. Peeling paint on a windowsill is major. Grass not being cut in December, major, but could wait till spring. So I'm just tired now to do my spring cleaning, basically.
Mr. Chairman, Mr. Thompson, are you registered? Are all of your rentals registered with the city of Cleveland?
Registered?
Yes, you're required for rentals to be registered. Are all of your properties registered with the city of Cleveland, and do all of your properties have lead safe certifications as required?
Well, they are not rental at this point. If they were rental, I would definitely have that. I've had rental property. I do not have any property that's now rental. The property that I do have, those items that you just mentioned, they are and will be sold. I am 71 years old, and I don't have the time, energy, or effort to do it anymore. I'm going to be selling everything that I have. So,
Mr. Chairman, he's asking for time to sell the properties. We would ask that you deny and remand. Thank you.
Well,
Mr. Chairman.
I'm not saying I'm not gonna do it because I want to sell it. I'm gonna do it because it needs done. So to cut grass, I don't see.
So, Mr. Chairman, if I may, based on that information, I would counsel Mr. Thompson that by definition, any dwelling unit owned by a corporation in the city of Cleveland is considered a rental property because you cannot own or occupy as a corporation.
Okay.
Properties under construction or for investment for the property of, or for the purpose of selling them is, it's considered differently, but it's viewed very, very narrowly. So, Mr. Chairman, because there's multiples, I would remind the appellant that it is the responsibility to have this done before we get there. It is not the city, the citizens of the city of Cleveland should not need to expend resources to tell you to cut the grass. That being said, I would also caution that if the expectation is to disperse of these properties, then it needs to be done quickly, or they must be registered as a rental property, because by definition, corporately owned property are rental properties. That rental process requires that you have a lead safe certificate.
Yes, sir. I absolutely understand, and I'll abide by whatever is needed to make sure it's done correctly and registered if I should have it more than the 30 days.
Okay, motion is in order to abate all violations by June 9th, 30 days, 2023.
So moved.
Okay, moved by Mr. Maskey,
Second.
second by Mr. Bradley.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks.
Thank you.
Okay, housing docket A 22022. It's 2195 East 70th Street.
Application and fees are in order. Notice of violation is exterior maintenance, issued December 2nd of 2022. Appeal received December 20th of 2022, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston, Law, for the record.
David Thompson.
Okay.
Yes, the grass, again, I've contracted with and have in hand a contract with the landscaper to cut the grass. And there was one leaning pole, a fence pole, I believe it was. Again, he's taking care of that while he's cutting the grass. So the cars have been removed. Grass is being presently contracted and taken care of. And this is the final one that I have. The same situation as with the others.
Okay. Mr. Vanover.
Mr. Chairman, we don't object.
Okay, motion is in order for June 9th, 30 days, 2023 to abate the violations.
Thank you.
Motion by Mr. Bradley,
Second.
second by Mr. Dink.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, once again, notice is going to be sent within 2 weeks. Thank you.
You're gonna have a busy month,
Sure.
Mr. Thompson.
I got a contractor that's doing it. I'm not, I don't have the strength to do it.
Okay, he's stepping. All right, you're not done yet.
No,
Yeah.
housing docket A 221-22, 38 13th East 153rd Street.
Application and fees are in order. Notice of violation is exterior maintenance, issued December 2nd of 2022. Appeal received December 20th of 2022, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston, Law. Would the appellate or his or her attorney or representative please state your name for the record?
David Thompson. This particular property is my home of my son. It's listed under David T. Thompson, if you look at the violation. And they've got my wife's name on there also, Teresa Thompson, who has no ownership in it. I did forward the violation to him, and he started repairs. Again, it was some little tuck pointing, 2-3 items. I'm not sure what it was, but again, it was issued to myself and to my wife, not to David Jr. So I don't know how we handle this, if they need to correct the record showing him being the owner, as he is, and he's working on the house as we speak.
So, Mr. Chairman, Mr. Thompson, are you saying it's David T. Thompson Jr. at the property 3813 East 153rd who owns it?
Yes, that's correct.
And he lives there, you said?
Yes, he does. He's been there for since he left home.
That is who is on the, it does list Teresa Thompson, but it does list him at that property as a responsible party. I do see where you were also served, but we do also, the city also does list it and served it to the property.
Okay, so again, I forwarded everything to him, and he's working on it. So
I have no objection for him, Mr. Chairman. I have no objection to him asking for time on behalf of his son. He's a family member. I really heard that.
Okay, how much time do you need?
I'm going to say for him, 90 days would be great for him. This way, if he doesn't get it, I'll stay on him and make sure it's taken care of.
Mr. Vanover.
Mr. Chairman, I would ask, I mean, if this, especially as an owner-occupied property, tell your son to clean the garbage up. I mean, that's, Mr. Chairman of the Appellate, this is why we get, and all of these cases came from complaints, from separate anonymous complaints. And it means that somebody in the neighborhood is unhappy looking at the garbage that's strewn around this property. And then once our inspectors show up, because somebody's complaining about the garbage and the dump, and it looks like there might be a tire thrown back there and a pallet up against the wall, then we're obligated to cite for other things. So 30 days to correct the conditions. I would ask that a much shorter time be granted to clean the garbage up in the yard and around the property.
I would ask the cleaning up the exterior, 30 days is no problem for the repairs to be done. I would ask that he's given additional time to tuck point, I think some chimney work, etc. And again, you mentioned a complaint. If someone had a complaint against me, someone has a disliking on me that went around in properties they thought were mine, is what they called and complained on. It wasn't I wouldn't say everyday citizen. For the things that I was cited for things I was cited for, like I said, I take care of it every spring. All my yards are in excellent condition. It's just someone had something against me, I guess personally, and made a bunch of phone calls and cited everything they thought I owned. So he needs to
Mr. Chairman, we would ask for 2 weeks to get the trash and debris cleaned up. And Mr. Chairman, the appellate, although I understand that it may have been somebody that had some sort of personal vendetta, the reality is when we inspected the property, the conditions do exist.
I understand.
So there's nothing, there's nothing we can do at that point. But if you can see from the pictures that there's a housekeeping and a maintenance of the yard, regardless of the structure, that is also required on this.
2 weeks is a good time for the yard, and just additional time to have the other things taken care of. I totally agree with the yard. 100% agree with the yard area.
Okay. So we'll give you the time. Motion is in order for May 24th, 2 weeks, 2023, to do the cleanup work, and to July 9th. Say July 9th. August 9th. Now we'll go.
Much appreciated. Thank you. That gives plenty of time.
Okay, August 9th, 90 days, 2023, to abate all violations.
So moved.
Okay, motion by Mr. Maskey.
Second.
Second by Mr. Dink.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Okay, notice is going to be sent out within 2 weeks. Thank you.
I appreciate you guys working with me. Thank you very much. Have a good day.
Good luck to
You too.
I'm signing off.
Okay. Housing docket A523 has been withdrawn.
36.
Okay, next docket is A 623. I think I'm not sure about the address. Is it 1020 East 74th Street? Does that sound right?
That is correct.
Okay. 1020 East, go ahead.
Application and fees are in order. Notice of violation is interior maintenance, issued December 6th of 2022. Appeal received. Let's hang on.
Mine's not dated. Mr. Chairman, the city will concede that it was received in a timely fashion. I don't know, it's not dated.
There's January 6th. The appeal was received on January 6th of 2023. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston Law. With the appellant or his or her attorney or representative, please state your name for the record.
Carl or Lord? Smith Jones?
Mr. Chairman, I do not see the owner in our participant list.
If you would
Okay.
swear at Mr. Vanover, I'll do my inquiry. Thank you.
You, Mr. Vanover, solemnly swear to tell the truth, the whole truth, so help you God.
You do.
Thank you, Mr. Chairman. To Ms. Davis, did the notice of today's public hearing get returned to this board's file for any reason?
To Mr. Chairman, to Ms. Aston, no.
Thank you. And did the appellant or anyone on the appellant's behalf contact this board in any?
To Mr. Chairman, to Ms. Aston, no.
Thank you, Mr. Chairman. Notice having been properly given and meeting due process requirements of notice and opportunity to be heard before this board, you do have the right to proceed to this hearing. Thank you.
Mr. Vanover.
Mr. Chairman, bear with me one moment. So, Mr. Chairman, we ask that you deny any more time or remand it back to the building department. According to the inspection record, the violation notice was closed, compliance final.
Okay, so we don't need a day, nothing, just go ahead and remand it?
Yes, please.
Okay, motion is in order to deny more time and remand the property to the Division of Building and Housing for any further action.
So moved.
Been moved by Mr. Maskey, second by
Discussion,
Mr. Bradley.
discussion.
Go ahead.
I believe there's some, she just called, is that this week?
Yeah, she was just calling to let us know
Okay.
that the violations were in compliance.
Thank
And
you.
she's gonna be sending us something in email.
Thank you. I just wanted I heard them say that the appellant was calling, so it's gonna get to the same place. Thank you.
Okay,
I'm sorry, could you repeat the motion for me again?
yes, the motion is in order to deny more time and remand the property to the Division of Building and Housing for any further action. And I think it was moved by Mr. Maskey, second by Mr. Bradley, I think.
Yeah, that's right.
Mr. Maskey,
Yes.
Mr. Bradley,
Yeah.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, notice will be sent out within 2 weeks. Okay, we have a time extension on housing docket A 13022 4211 Store Avenue.
Application and fees are in order. This is a time extension for interior exterior maintenance that was issued on February 3rd of 2022. We heard this docket on June 22nd of 2022. At that time, the board granted the owners until July 6th of 2022 to acquire all permissions. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston Law. with the appellant or his or her attorney or representative.
Ludi? Is that what's your last name? True self you got?
You're muted, Mr. Smith.
There we go. Yes, I do.
Okay.
Okay, very good. Go ahead and let us know what your plans are here.
Oh, the plans are to finish up the property. We have a few more violations to complete. We just ran into issues with naturally the contractors and also the tenant that was in place that wouldn't allow us into work a lot of times.
How much more time were you looking for?
60 days would be fine.
Okay, let me go over to Mr. Vanover.
Mr. Chairman, again, this is a rental structure that's corporately owned. What is the, if I may, and there are a couple notices of violation present. Who is the, so it's Masura LLC is the owner.
Correct. I do the for them.
Okay, say that again, sir.
I manage the property for them.
Okay. Mr. Chairman, we don't object to 60 days with no further extensions. I mean, it's been, more than a year that this has been going on and dragging along. It is a rental property. Their registrations are current, and it appears that the lead safe certificates have been submitted. So I will allow a little more time, but this is an extension on an extension that's already been granted by this board.
Got it.
Mr.
Okay.
Chairman, I just, and I don't know if Mr. Vanover saw them, the photos for the stairwell handrail, maybe it's just being a rental. Mr. Smith, were those the handrails that looks like they were rebuilt, were those inspected by the inspector and approved? Because to me, it looks, they might, you can't have them so long for kids' heads so they don't fit.
So, Mr. Chairman, the expectation is that the work will be inspected and approved by the inspector.
Thank you.
I won't present an opinion on whether they comply or not here because it's not obvious, but they will need to be inspected. And to Ms. Aston's point, those spindles do not comply with the code. If the photos are showing me what I think I'm showing, and they have to be less than 4 inches apart.
Okay.
Right.
Thank you.
That's just a heads up, but we will conduct an inspection accordingly.
Okay.
Understood.
Sounds good. Okay, so a motion is in order to allow 60 days till July 9th, 2023 to abate all violations with no further extensions.
Okay, well, I have one quick question. If everything is done before the 60 days, I just call the inspector and have her come out?
Absolutely.
That's correct.
Sounds good.
Okay, go ahead, motion.
Move.
Mr. Bradley,
Second.
second by Mr. Dank.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Okay, notice will be sent out within 60 days. Thank you.
Thank you. Have a great day.
All right, next docket is adjudication order A9123, 828 Huron Road.
Application and fees are in order. The notice is an adjudication order to several Fire Prevention Bureau codes as well as Ohio Building Codes. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston, Law. With the appellant or his or her attorney or representative, please state your name for the record.
James Hounshow.
Joseph Hannah.
Oh,
I don't
that's
understand.
Joseph Hannah.
Yeah, talk louder.
Did you hear the second one, Mr. Chairman?
no, I didn't even quite catch. What's the last name on the first and second?
Joseph Hannah.
Hannah, okay.
Jim Hounshow.
Okay, well, for both of you, if you're going to be giving testimony, solemnly swear to tell the truth, the whole truth, so help you God.
I do.
I do.
Okay, go ahead and let us know what the plans are.
Yes, sir. Well, I'd like to go over the, if you wouldn't mind, the history of the building. I mean, I'll be very, very short. It was construction in 1986, 1999. That was for Grace Episcopal Church Rectory. It was sold in 1919 to American Savings Bank. They kept it through 1969, then vacated the building. From 1969 to 1984, there were small various businesses, which, you know, we couldn't look up or find. In 1984, the present owner purchased the property. From 86 to 87, it was George's Deli office, then an apartment. 89 through 93, cafe, office, and apartment. 95 through 98, New Market Tavern, office and apartment. Then 98 through 2008, Aleshi's was on the first and second floor. These were all restaurant bars, and with the apartment for the first couple of years. And then 2009, 2018 was the Huron Point Restaurant and Bar. So it's always been what we're looking for on the adjudication is the restaurant first and second floor and the apartment on the third floor. We're not asking for a change of use. Okay, I'd like to go over another thing kind of quickly. The basement, basically storage, prop, that's 1,311 square foot, the first floor. Restaurant bar, 1,572, 1,572. Second floor, 1,505 square foot restaurant. The apartment is 1,200 square foot. Maximum travel on any floor, if you took out one of the stairwells, fire in a stairwell, whatever, would be 72 foot. The basement, I'm sorry, the first floor has 2 means of egress. Second floor has 3 means of egress. 2 new stairwells with 2-hour firewalls. Third, and a exterior, stairs. Yeah, fire stairs, sorry. The third floor, the same thing, 2 means of egress with the exterior fire stairs. There's a 2-hour separation wall between the second and third floor. And the 2 stairwells have 2-hour enclosures. So from there, I'd like to point out, well, I'd like to ask we did turn in, we received the adjudication A1, and which we turned a copy of the plans into the appeals board. So I would say 3/4 of these on this adjudication docket have been complied with and are on the plans. Now, this is where it starts. The back in 2020, 4/5/2020, Neshkin was hired for the construction of the building. In July 28th, 2020, a building permit was issued to Neshkin. From there, they hired, and remember, this was during the coronavirus time period. So they started doing the work. Then in 2021, Neshkin pulls off site. The owner went, he's looking for somebody to continue the work. The work was ongoing. And they hired a company in October of 2021. They pulled, the necessary permits, negotiated, with the contractors, and started work again. Up until October of 2022, and all the work was ongoing, and this building has historical tax credits also. Neshkin, I'm sorry, they want to change the permit, the name of the permit, into the new contractor. So met with city officials, got the letter from the ex-general contractor, went to transfer it, but they didn't have a copy of the plans for the project and the original permit. At that time, they told them to, submit new plans because they couldn't find the other plans. They did submit the new plans. In the meantime, I found the plans at Neshkin's in a warehouse they had. Resubmitted them. They did apples to apples and said, hey, things changed on the updated plans. Naturally, there was changes historical, but the stairs, we added a stairwell, from the first to the third floor, an additional stairwell, which was negotiated on the first permits. So we wouldn't have to have the sprinkler system. So now they do the plan review, we get the adjudication. We answered most of these questions. So we're actually here, and I don't know, Mr. Vanover, if I can just skip through this, I want to table for right now, the sprinkler system. Fire extinguishers, yep, noted on the plans. Identification, classification done. All rooms, restaurant, dining assemblies, which kitchen equipment without hoods. We have one hood, which we're reusing, which is on the plans. Mechanical plans, there was separate notes. We addressed those. Aisle dimensions, we can add those. That's something that was just added as far as we know. Occupant loads, we have that. Signage detail, it's going to be fire safety evacuation plans. I mean, those are things, well, actually, you put those on the plans, Joe?
Those were on the plans, and also the alarm system were always on the plans from the engineers. They were submitted by a licensed fire alarm system and was approved by the building department and the fire marshal. We actually have the approved set here, and that's what allowed us to go ahead and we actually purchased the system. The whole entire fire alarm system is waiting at the job site, ready to be installed, and before this came up.
And we do have a copy of the actual permit that was given with the original plans that we have and signatures. So
this is a full set done by a licensed fire alarm system company, and it has all the notes in here, and it basically says everything that the drawings are saying, that it's non-sprinkled, and it gives all the details of the strobes and where the pull stations need to be. Even the hood system has to be tied into that, the smoke detectors and the ductwork. Everything was detailed through these plans. It was approved on May 30th, 2021 by the fire department as well as Mr. Vanover.
Permit issued the same thing at the same time. And it also noted on their non-sprinkler building on the approved plans from the fire department and city official. So that's basically it.
Okay. Mr. Vanover.
So, Mr. Chairman, just to frame what we're looking at, this is an adjudication order for an existing restaurant. Just to clear some things up, there was a set of plans for the renovation that were submitted and approved back in 2019, I think. And then the project went forward and then stopped. And it was stopped more than I will object to the fact that we couldn't find the plans because that's not accurate. The plans were discarded because of the age of the project under the state of Ohio record retention policy. They swapped out contractors. We had been made aware that the contractor was not going to complete it, and under local ordinance, they needed to replace their contractor. However, there were no approved plans that in the department and the permit had expired because of the time period. So they needed to submit. We asked them to submit a set of plans that we could review for the project because the approved plans had been discarded. Mr. Honshaw was able to find the old plans as well as, and then for us to compare to the new plans. Upon review, we identified that the new plans did not match the old plans, that there were substantial changes made between the approved set of plans and the plans they presented. Those changes included structural changes and then details of, within the project. It was determined at that point that there was too much changed to simply reapprove the old plans. And we did a plan review and it was adjudicated. There was many items found to be in conflict as are included in the adjudication order. And the largest being that the restaurant, based on our review, had expanded from what was on the first floor into the second floor. The occupant load for the second floor exceeded the occupant load allowed for a space with one exit. So that's why during the initial review, an additional exit was required. That's why the additional stairwell was required. And I'm not sure, and I will allow Mr. Hanschel to testify what exactly he is, what is he asking for? It appears that he's objecting to the adjudication order. And I can argue that why the adjudication order is valid and accurate. Or he's asking for a variance due to whatever whatever conditions he believes are present that should allow for a variance. I'm not clear on what the ask is at this point, and I can, in order to make a response.
Okay.
Mr. Chairman, I just have one question, Mr. Chairman, to the appellant. You stated you gave plans to the board. Did you also give those same plans to Mr. Vanover?
As they were delivered, same electronically, the minute I got them, 4 sets went to
Just
the
want to make sure that.
city and
that-
one went to,
Tom, you got
yes.
those he's talking about as well, right?
I'm sorry, say that again.
He stated he electronically submitted plans to both the board and to the building department. I just want to make sure the building department received them.
no,
We received them last week and as a response to the adjudication order, and they have not been reviewed yet.
Okay, I just want to make sure that's all. Thank
yes,
you.
definitely.
Mr. Chair, I didn't receive those plans, so if you submitted anything to me,
I didn't submit it to you, I'm sorry.
I got those
Carmela?
pictures, right?
Are you
but I didn't-
Carmela?
Yes.
I submitted them electronically to you, and
Mhm.
I even asked for verification the same day I dropped them off.
They are in
I could
response to-
resend it. I could pull out of my inbox right now.
Well,
They were
if it's in
sent.
response to the adjudication order, they have to go through Mr. Van
They did,
first. So
but
that-
for the
Gotcha.
appeals board, Carmela asked me to send those,
Right.
and I sent pictures along and the letter from the owner.
Yeah, I got the letter from the owner and the pictures, but maybe it caught up
Okay,
in the firewall or something. but I
I'll
didn't receive
resend those.
it.
Okay.
Okay.
Mr. Vanover, we received this adjudication order. We're taking care of everything on there. I think what we're asking for, since there's no change of use, and we have 3 means of egress for the second and third floor. And the plans originally, nothing's changed square footage, nothing's changed anything. We're asking that in the adjudication that we are not required to have the sprinkler system.
So you're asking for a variance from the requirements listed for the sprinkler system?
Yes,
is that
sir.
correct?
Yes, ma'am. That's it. Am I correct, Joe?
If you're
Everything
asking-
else?
If you're asking for a variance, I mean, is that different than what this is?
No, this is what
It's
it
all
is.
part of the same thing? Okay. And that's
Or
what you're
this is
asking,
what
yeah.
we're asking.
Mr. Chairman, based on what Mr. Hanschel has said, he is attesting that it's not a change of use. And therefore it wouldn't be a variance, because if it was legally established if it was a legally established use for the apartment. So let's get into that. The apartment requires, all residential uses require a sprinkler system. And an assembly space with an occupant load more than 99 also requires a sprinkler system. Two specific issues that are separate from one another. The apartment requires the building to be sprinklered throughout, and the restaurant requires the assembly space to be sprinklered within the assembly space. We do not have in our records any records showing that the apartment was existing. And I believe he's got photographs to provide showing that it was. And our records do not indicate that the restaurant was occupied the second floor of the space. So the second floor occupancy is what requires the second means of egress because it's an occupant load of more than 50. But also it increases the total restaurant occupant load from whatever number, the last CO we've got says 60, or at least the CO that was submitted with the or that was uploaded to the record here shows that. So if the argument is that the apartment is existing and therefore it's not a change of use and therefore covered under Chapter 34, that was not presented that way in the plans. So we can entertain that conversation, that they can present that argument to the board.
So if it's not a variance, we're here today, what would I call it? What I ask, we're appealing it. We're appealing part of the adjudication. One item.
You're objecting, Mr. Chairman, there's an objection to the adjudication order requiring a sprinkler system. And therefore, they need to prevent, there's an objection to the requirement for a sprinkler system because it is an existing use under Chapter 34.
And you're saying that does not apply, is right?
I'm saying that we do not have any records showing that this apartment existed or that the restaurant occupied the second floor or that the restaurant had an occupant load of more than 99 people.
Okay.
Mr. Chairman, Helen, did you provide any of those documents with your submittal in the revised plans that the building department have not yet reviewed to show that, to document that it is an existing use and or meets those requirements that Mr. Vanover just stated?
Well, we went to records, okay, we couldn't pull anything. The only one I pulled up in records was 1991, and it doesn't specify floors, and say first floor only, second floor. We went through the history of the building with the current owners. That's how I created the history, which I have. Then other than history, I created, I shouldn't say we as a team, we have, when Mr. Vanover stated no work was done, that's why after the project was abandoned, or basically they discarded everything.
It was not abandoned.
This is where I'd like to, I did a timeline issuance, I mean, a complete timeline of what was done, you know, during this time. Matter of fact, our last inspection was right here.
City was actively involved.
They were actively involved. It was
inspecting, inspectors were in. You actually got inspection approvals as recently as
last month.
Did you
last
submit that
month.
to Mr. Vanover?
Well, they know about it. I mean, this was just as of Inspector Bob Bauer came for inspection, closed our outstanding permits for the windows, terracotta, structural, and exterior.
All approved.
This was all approved on 3/9/23 by the Inspector Bauer.
Signed off
He
on
took
it.
over,
One at a time, please.
he took over Inspector Santoro's, job.
So the work was ongoing is the point.
The work was ongoing, and this timeline, I showed, I don't know, 26 different things that were done. The stairwells were ongoing, well, the demolition, the stairwells, the exterior, the windows. They started plumbing, electrical, all those permits were pulled. And then you gotta remember, in the timeline, and I know nobody wants to hear it, but I also marked that up, during the coronavirus, and we had city riots, whatever. Yes, there was a law, maybe a 3-month law, 4-month law, but in this timeline, it shows everything. That work was ongoing, and I was not there. Joe, can you testify? That work
Absolutely.
didn't stop?
Absolutely, it was ongoing. In fact, the construction manager that they hired, Snashkin, practically went out of business.
He ended up dying.
The owner died. The superintendent basically handed us and said, you know, you're on your own. The owner hired construction manager to carry the sub-trades. Sub-trades did their part so we could find a new general contractor, which everything was a process. You throw the historic tax credits that we had to satisfy everything that they wanted to see on the drawings. The city storefront program had all their requirements that we had to do with that. Everyone's pulling their permits, the project's ongoing, and we get to a stage where the new contractor needed to officially go and put his name and switch the name from the old contractor to the new contractor. It had to do with fees and that kind of stuff. And that's when we found out that there was no record of our drawings at the city, and that, you know, you guys are, you know, and actually I was told that it sounded like that it's no big deal. Let's just start a new permit. Once that process started, all bets were off. Every negotiation, every approval we got, they're claiming that none of this existed. And yet we showed the original plans, and it's got everyone's name on it. It's got everyone's stamp on it. It's got every signature. We got all the inspections. And then they all of a sudden say, oh, by the way, you need a sprinkler system. And we're like, wait a second, where did this come from? And so that's kind of in a nutshell what we dealt with. And the owners are upset because this project got dragged a long, long time. Every single restaurant in the neighborhood goes out of business. There's one guy left standing. He's trying to build his restaurant. And then in the 11th hour, it's 3 months before, and they build all the stairwells and all the fire alarm panels. Everything's ready to go. And he's 3 months away and he wants to finish his job. And then they step in and shut us down, basically say there's no permit. In our opinion, as of that moment, there was a permit. No one told us there was not a permit. We were working under the permit with the inspectors and with everything that we're supposed to do. We're doing everything on the up and up. And then this comes up. So now here we are here, lost 2 months for them to review the plans.
4 months.
Okay, it's become that.
And we're in jeopardy as of last month on the 31st, in jeopardy of losing our federal tax credits.
The federal tax credits, the financing for the restaurant portion of it he could lose his financing at this point. I think he's been making payments all this time, even though the place is not open. And so, you know, we are here sitting with you, appealing this and saying, we had a permit, we have signatures of a signed fire alarm system, even though they told us it wasn't even on the plans. We have the signed documents in the shop drawings. We have everything here. And all we're saying is that we were approved once. The building has been upgraded to new stairwells, new fire exits, and
fire rating.
And that we were approved to not have a sprinkler system. You know, Had we been told that at the beginning, we probably would have tried to negotiate or work that in somehow, but we're in how many years in construction of getting through everything that we've been through? And now they tell us that you're gonna have to go and dig up the street and bring in a water line with utility companies. I mean, it's the most ridiculous comment I've ever heard.
Mr. Chairman, I'm gonna, if I may, I'm going to object, Mr. Chairman, to Mr. Hannah. There was a approved set of plans that were submitted back in 2019 and gained approval, correct?
Yes.
Okay, do those plans match the construction that's in the building today?
The plans that we submitted to you today had
No,
structural.
the plans that you keep referring to where you gained a plan approval?
Yes.
And where you gained, you had a permit to do all of these things. Is that the construction that is in the build that you have conducted in the structure?
Yes, with exception to the structural.
With
We had-
exception to, no, so you're saying that other than the structural changes where you swapped out the steel construction for wood construction?
Yes.
Everything else matches? Mr. Chairman, we'll object that is not true. That is not accurate. What Mr. Hannah is attempting to do is saying that they're just submitting new plans. The reality is that they've had interior build out items that have been relocated. They have changed the plans considerably. They've changed major structural elements. We were prepared, just for the record and for my objection, we were prepared to compare the new plans to the previously permitted plans and simply reissue those plans if they were approvable. However, there has been considerable changes. They were never approved, and I will say never approved, to build what they have built. And as ridiculous as Mr. Hannah may find the comment, the fact is, and I understand that there was the pandemic and there was we've gone through this with tens of thousands of construction projects in the past 3 years. The reality is there is no indicia on the plans that show that there even request a Chapter 34 exception for this, and for us to review and approve, and that's why it was adjudicated, because we had a meeting and we discussed this. I explained that the plans for what they're asking for are just they're just incomplete. So I will object to the statements that they had an approval to build what they're building, because they never had approval to do what is in the new plans. That's why we were required to review them and address them. As far as the matter of the sprinkler system, whether or not it's required, it simply revolves around whether these are an existing use or they are not. There has been nothing presented in this plans for the new permit or the old one, really. Allegedly there was several conversations, but there's been nothing showing that this apartment ever existed other than the photographs that are before us now. I will also add that as part of the initial building permit number B18026855 was submitted for this project. It was never pulled, but it was submitted and a plan approval was issued for the interior demolition of interior partition walls for the purpose of getting ready for the new build. The text in that permit was second and third floor business offices, interior alterations, the removal of interior non-bearing plaster walls, and the removal of all plumbing pipes and fixtures on the second and third floor. Their submission called the second and third floor business offices. So it's not a ridiculous statement, because they didn't complete the project. I will tell you that the last actual permit, there has been inspections on the property, and the last substantive inspection, if I may bear with me a moment while I pull that up, there's been several no progress inspections, but the last substantive inspection where there was anything conducted was for the second floor roof area, and that was 5/14 of 2021. Inspector Bauer's inspection from 3/9/23 is a required inspection when you change from one contractor to another. So to verify what work has been completed in an expectation of transferring the permit. So I would say the comment that Inspector Bauer has been out there and has approved everything and is fine is at least inaccurate and at most just disingenuous, because his purpose there was not to inspect to a set of plans that we hadn't received yet. That being said, there are photographs that show that there's some remnants of what looks, like an apartment, but we still don't have evidence of the second floor of this space being used for an assembly purpose. And I can opine on the condition of the fire alarm plans as well, and explain the difference between submitting a fire alarm plan to the Fire Prevention Bureau and actually using proper architectural practice and including those items on the building plans as well. We're willing to review and approve any corrections that they have made. I would ask that they specifically identify which item they're objecting to, because there's been a laundry list of things that they've completed or that they have altered or that they have changed, so that we can make a determination on whether or not the board is going to grant a variance, whether the board is going to uphold their objection to the order as written.
Well, let me jump in here, because I'm afraid I might lose some board members. I don't want that to happen, but there's no way in the world that we at this point, without further them talking to you at the city, we're going to have to set this off maybe for another 2 weeks, so they have a chance to come in and explain the things that you were talking about, Mr. Vanover. And if they have a specific need that they can put before us for a variance, then we can do it. But there's no way in listening to this now that we can engineer this out and say, okay, let's go ahead and give them a variance on this, because I don't think we're there yet. I think they really need to talk this out with the city and maybe with fire and see what they can do. If they're trying to avoid having to put the sprinkler system in, then there may be some things that they need to do or to explain. But I think this is going to have to be set aside for at least 2 weeks.
We have no objection, Mr. Chairman.
Okay, so we hearing that? Can we get them back on the docket within 2 weeks? And then I'm going to tell you to get together and then be specific as to what it is that you're looking to do.
So what he asks is for you to go back to meet with the city. Y'all hash some things out and then come back with clarification on exactly what the ask is.
Yes.
So do you think you can do that in 2 weeks, or you need longer time?
No, I mean, if Mr. Vanover will make an appointment now, I'll be here tomorrow.
Well, if they can get it done, then we put it on for 2 weeks. If not, if it doesn't look like it's going to get there, then we'll have to move
So
out.
I'll send you an email to see where we at, so I can know to add you on to the 24th docket or the first one in June.
Okay, no action will be taken now.
Thank you, Mr. Chairman.
Okay. Thank you. Okay, so we're going to move on to the next docket. Housing docket NPR 1-23 11811 Forest Avenue.
Or is this automatically sliding again? Could you put it on the last one? It's automatically going through.
Yeah.
Okay,
Thank you.
you're welcome.
Is Cedric or Miracle Planting on the participants?
They never paid, so
Okay,
application and fees have not been met in this particular docket. For the record, NPR is for non-payment received for a formal appeal process.
Okay.
So
So
today,
the-
the owners have failed to meet with the board to file the formal appeal and to pay the necessary fees, so they are not here today. So present for the hearing would be Tom Vanover, Building and Housing, and Hattie Aston Law.
Okay, solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Go ahead.
Mr.
Mr.
Chairman.
Hanover.
Well, Mr. Chairman, preliminarily, since there is technically no, technical appeal before the board because they never completed their, steps to bring jurisdiction to this board, I will, for the record, just so that we're clear, to Ms. Davis, will you read into the record your contact or service or, attempts, communications with the appellant in case they should take further action? Because at the conclusion of this, Mr. Chairman, I'm going to ask that you dismiss this matter for failure to prosecute, remand to the city of Cleveland, and provide us with an emergency resolution that we would mail to the, I would ask that you would mail to the applicant who failed to do this because of the fact that it is a condemned structure in the city. Thank you.
Okay, you're gonna have to write that up because you're very echoey on the things that you're asking for. So this to be put into the record as you have stated it. Okay, if we will
Thank you, Mr.
remand
Chairman.
it.
I'm just asking if Ms. Davis can, for the record, read in her contact and communication with the attempted appellant on this property, Cedric and Miracle Blanton.
Yes, she can do that. Go ahead.
To Mr. Chairman, to Ms. Aston, the board had sent mailings that we found to the following addresses: 3467 Green Road, apartment 5A in Beechwood, Ohio. It was returned back from United States Postal Service as attempt or not known. We again sent them a notice to 5101 Thomas Street in Maple Heights, Ohio, 44137. As of today, the United States Postal Service has not returned our certified mail green card as whether rendered service or return to sender not known. We sent notice to 23351 Chagrin Boulevard, apartment 405 in Beechwood, Ohio, 44122. As of today, the United States Postal Service has not returned back to the board notice of service or return to sender not known. And we also sent another certified letter to the address that the violation notices were issued to, and that address is 11811 Forest Avenue in Cleveland, Ohio, 44120. That has not been returned back to the board by the United States Postal Service as rendered service or return to sender unknown.
Is that it?
And Mr. Chairman, to Ms. Davis, have the appellants contacted you, the board at all, any phone calls or emails or any of that matter?
To the chairman, to Ms. Aston, on January 24th at 2023 at 10:15 a.m., I made contact with a cellular number to Mr. Cedric Blanton. I had expressed to him in that call what the formal procedures were. At that time, he told me he would have a conversation with his wife and they would come down to file a formal appeal. When they failed to come down, I did follow up with them again, and that number went straight to voicemail, and then later on was disconnected.
And Mr. Chairman, finally to Ms. Davis, as of today, as we sit here today, May 10th, 2023, has anything further been provided to this board in an attempt to exercise this appeal right?
To the chairman, to Ms. Aston, no.
Thank you, Mr. Chairman. Based upon the interaction and the testimony of Ms. Davis, we would ask that you, as indicated on the agenda, dismiss this failure to prosecute and remand to the City of Cleveland Department of Building and Housing for such failure to prosecute. And we are asking for an emergency resolution to that effect. This board has gone over and above any attempt to allow and to have them, the Cedric and Miracle Blanton, proceed on any due process rights for appeal. Thank you.
Okay, so we will, the motion to dismiss for failure to prosecute and remand it to the city of Cleveland for any building and housing for any further action. And we will do the emergency appeal through Ms. Davis. Motion is in order.
So moved.
Motion by Mr. Dink. Second.
Second, Mr.
Mr. Maskey? Mr. Bradley? Mr. Dink?
Yes.
Mr. Gallagher?
Yes.
Mr. Bradley? We need to hear you. We only have 3 members.
I see him. He's there.
Is he muted?
No.
I don't see him
St.
muted.
Tony, please come around. There's something lost and must be found. Please help us.
I know Mr. Maskey, I think, had to leave us, but
Yeah.
just need to get Mr. Bradley
Yep.
to call in. Did he say yep?
No, that was me, but I agree with you.
We lost a great opportunity there.
While we're waiting, can you repeat that last address for me, Carmela, please, Ms. Davis?
The one in Beechwood, Ohio?
No, just the docket address, just flip back 2 slides or 1 slide.
11811 Forest Avenue.
Thank you.
Oh, look like we lost Mr. Bradley. I'm trying to call him again.
Oh, boy.
That's the case. We can't adopt anything today. It's not gonna be
I've
good.
been praying to St. Tony that we find him.
Well, he's been with us up until this
Yeah,
last.
I wonder if he's having technical issues. Swimmingly.
I'm gonna try to have the 2 minutes.
Momentary break.
Come on, Howard.
Yeah.
There you are.
Oh, good. Wait, we just missed Carmella. Hold on one second.
Say yes.
Yeah, or you can just accept that they gave a motion on the table.
What did you say? I didn't understand you.
Well, just
There's a
say
motion
yes.
on,
Yes.
there's a motion on the table, Mr. Bradley, to
Yes.
dismiss. Thank you. No objection on behalf of the city. He did say yes.
Okay, very good. Okay, that covers
And it
that.
is on YouTube. It is live recorded.
Right. And so we just need,
Yeah, stay with us, Mr. Bradley.
Yeah, I'm here.
Okay. Mr. Gallagher, if you want to continue on.
we can, yes. So we have that's called, they'll be given notification if they, I don't know, they don't respond, but anyways, they'll be given notification within 2 weeks. So that takes care of that. So we have approval of resolutions. We got A 21122, A 21322, A 21522, A 21622, 22322, A 123, A 1323. Motion.
So move.
Second.
Okay, motion by Mr. Bradley, second by Mr. Dank.
Carmella, just say call the roll. Oh.
Call the roll, right? Mr. Bradley.
Yes.
Okay, Mr. Dank.
Mr. Dink,
Be careful.
Yes.
Mr. Gallagher.
Yes.
You don't need to run.
Okay, that took care of that. Approval of the minutes for April 26, 2023. Are there any additions or corrections?
No.
Okay, motion.
So move.
Moved by Mr.
Second.
Bradley, second by Mr. Dank.
Mr. Dink,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher.
Yes. Is there any other further business that we need to take care of?
Did we approve the meetings?
Yeah, he did, Mr.
And approve the resolution?
He did. He came out and said yes.
Okay.
It's on YouTube.
Thank you.
Unless Tom does, there's nothing further officially on behalf of the city, Mr.
Okay,
Chair.
very good. Well, we are now adjourned. Thank you.
Thank you.
Have a good day.
Thank you.
Patty, can you stop by and see me real quick?
I will, but I'll be a few minutes because I have to run something by Carmella as well. Okay?
That's fine.
Thank you. Have a good one.